asking you, Attorney Garrity, have you reviewed the complaint with Ms. Montgomery? And did you discuss with her the maximum penalties for the charge?
I did.
And does she wish to enter a plea at this time? All right. Ms. Montgomery, you reviewed the complaint with your counsel? And you understand the maximum penalty for this charge? And you wish to enter a plea of not guilty at this time, is that correct? All right. The clerk will enter a plea of not guilty on this charge. What we're going to do now, Ms. Montgomery, is I'm going to take up the issue of bail. I'm going to hear from the state first, and then I'll hear from you and your counsel. You may be seated. Attorney O'Neill?
The state's request is slightly different from what's in the proposed bail order, just because I didn't have the capability to scratch out the corporate charity part. The state's request is a $5,000 cash-only bail. That would also have conditions of no contact with Adam Montgomery. If the defendant is released, that she live at a specific address, of which I'm not aware, which is one of the issues I intend to raise, that she not travel outside of New Hampshire, that she not possess a firearm or other weapon that's delineated there, that she not consume an excessive amount of alcohol or use any narcotic drug or controlled substance, that she sign a waiver of extradition, and that if she is released, that she check in daily in person at the Manchester Police Department. The basis for this request, Your Honor, is the defendant's status as flight risk, and what the state would argue is clear and convincing evidence that the nature of the allegations presents a substantial risk that the defendant will not appear, and that there's no reasonable alternative that will assure her appearance. A lot of this is grounded in the defendant's criminal record. I'll admit that it's not the most serious record that this court has seen, but it does involve great concern for her ability to comply with court orders. The record begins in November of 2012, when she was convicted in the Grafton Superior Court of Class A misdemeanor dealing in or possessing of prescription drugs. She was at the time sentenced for 12 months, suspended for 2 years. About 9 months later, in August of 2013, about 8 months later, in July of 2013, she was convicted of willful concealment, a Class A misdemeanor, and then what is perhaps most concerning to the state, a false report to law enforcement, a Class A misdemeanor. Those appear to have triggered a violation of her probation on the Grafton Superior case, which resulted in 63 days credit for time served, and an order that basically she successfully completed a 28-day residential treatment program. The final conviction on her record is from September of 2015. It's a Class A misdemeanor theft by misapplication, where there was a deferred sentence that it appears she successfully completed, and the sentence was subsequently completed. The concern for the defendant's inability to comply with court orders, which would contribute directly to her status as flight risk, comes from that false report to law enforcement, which was made at the time when really the potential consequence was the Class A misdemeanor penalty on that charge of 12 months in the house, and the 1 year suspended for 2 years that she had in the Grafton Superior case. That was, therefore, a case where basically the consequences were 2 years. Today, she's facing what is the most serious charge she's ever faced, a Class A felony, where the potential the potential maximum penalty is obviously 7.5 to 15 years in state prison. If the defendant was unable to comply with the condition of her suspended sentence, if she committed the crime of false report to law enforcement, then the potential penalties are much smaller. The state would argue that that is clear evidence of her flight risk, which would also be an inability to comply with the court's order to return for future court dates. Further raising concern as to her status of flight risk is the fact that because of this charge, the defendant may lose where she's living basically. She was arrested last night at Pitt, at Families in Transition here in Manchester. I wasn't present, but from what I have been informed by police and what I've been informed by Attorney Garrity, there was some conversation from staff and or administration there that this charge may cause her to lose her placement in that facility. That would weaken her ties to the city, weaken her ties to New Hampshire, and further add her status as flight risk. What I'd also argue is, going back to something I said previously about this being the biggest charge the defendant has ever faced, the most severe consequences she's ever faced, I believe it's appropriate for the court to consider the strength of the case. If the court is going to impose a cash bail that may potentially result in the defendant's pretrial detention, the court needs to consider the nature of the allegations. What I would suggest to the court is, based on what the court has read in the affidavit, based on the charge itself, this is a strong case. This isn't a case where the defendant may think she can count on witnesses disappearing or changing their stories or some sort of impeachment tactics by her counsel. This is basically a white-collar case where the evidence is documented, the witnesses are state employees who will be relating statements made by the defendant herself or the lack of statements made by the defendant herself. So not only is she facing the most severe potential consequence she's ever faced, but it is a strong case, which further contributes to her status as a flight risk, and again, would be in those nature of the allegations that the court is it's appropriate for the court to consider at this time. So for those reasons, the state argues that the $5,000 cash bail.
What is the status of her children at this point?
Currently, I believe that they're with the mother. I believe DCYF was notified last night.
Right. For the individuals that are joining us on WebEx, please make sure your line is muted. Please mute your line. Thank you. I'm sorry, go ahead.
I believe DCYF was notified after the arrest last night, but that's as much as I'm aware of. That, of course, is to the 3 children whose location is known.
Thank you. Garrity?
In terms of the conditions laid out by the state, we're in agreement with those. The disagreement we have is with respect to cash bail. We're asking the court to release her on personal recognizance bail. To address the risk of flight, I would suggest to the court that's extremely minimal. Ms. Montgomery has lived in New Hampshire since she was 9 years old. She's currently 31 years old. She went to West High School, left high school in her senior year, got her GED in 2009. Her mother lives at 258 Dubuque Street in Manchester. She has an aunt that lives in Manchester. Her grandmother and uncle live in New Hampshire.
Hey, Victor, did you see that thing I just sent you guys? Okay. Thanks
Please
so much, Victor.
please mute your line if you're on the WebEx. I'm sorry. Go ahead, Attorney Garrity.
She has one brother that lives in Texas, but basically the majority of her family live in New Hampshire. She has 3 young children. They are 4 years old, 2 years old, and 1 year old. She was residing with them at 177 Lake Ave at the Families in Transition location. She had been residing there since July of 2021. They are now in the custody of her mother. I've spoken with her mother, Christina Lubin, who's told me this morning that if KAYLA was released, that KAYLA could come and live with her at 258 Dubuque Street. She's resided at that location for about 14 years.
Attorney Garrity, just so that I understand, she was living at Families in Transition with the children since July of 2021, and the children are now
With the mother.
okay. But custody hasn't changed.
It has not changed. And it's my understanding that to reside at Families in Transition, she has to have the children with her. That's a little I know about that location. But she was also working. She worked full-time at Morgan Records Management. That's located on Frontage Road in Manchester. She had worked there since September 2021. That was a full-time job. She was working 6 a.m. to 2 p.m. Prior to that, she worked at Project Flagging in Hooksett. Prior to that, my understanding, she worked at Dunkin' Donuts in Manchester. So she has a history of employment. She has a close relationship with her children, and she's got significant ties to the area and has a place to reside. But the $5,000 cash bail, given her limited resources, would lead to her detention. And I think the whole point of the amendment to the bail statute that took place a few years ago is that financial resources should not be an impediment to people being released on bail. There are conditions as laid out by the state in their proposed bail order that would assure the court and the state that she would appear in future court appearances. And just with respect to her compliance with court orders and bail conditions and the prior record, I know the state talks about the events that took place in Grafton County. She was about 21 or 22 years old at that time. She didn't have her children at that time. The last conviction, and what the state didn't tell you, is that that conviction took place in 2015. That was a deferred sentence that, as I'm sure the court knows, requires that she come back to court and show compliance. She did so in 2016. That conviction also required that she undergo a LADAC evaluation, at least from what I can see from the record, that she comply with a LADAC evaluation and comply with any recommendations. From the record, in September of 2016, she was able to show the court she was in compliance and the case was closed. Since that time, she's had no prior interaction with the criminal justice system. All of that took place when she was approximately 25 years old. She's now a woman of 31 years old, 3 young children, and her lack of record since 2015, I think, indicates to the court and her compliance with the events and books at this report shows that she can comply and will comply with court orders and show up, as she did in 2016, with any scheduled court appearances. So I would ask the court to release her on personal recognizance with the conditions laid out by the state, with the condition that she reside with her mother at 258 Dubuque Street. That's on the first floor in Manchester. Thank you.
And there's also no objection. You understand the state's request is that she check in daily with the Manchester Police Department.
Yes,
Okay.
no objection to that.
Okay.
If I could,
Yes.
the state would be opposed to her living with her mother. This is due to the circumstances of her arrest last night. The state's position would be that defendant living with her mother wouldn't be conducive to her compliance with court orders and coming to court. Basically, as she was arrested last night, her mother said words to her to the effect of, "Don't talk to the police." Which doesn't seem to be conducive to somebody who's trying to stay on the straight and narrow and come back to court.
Attorney, just a second, Attorney Garrity. Attorney O'Neill, I mean, you don't disagree that she's charged with one count of welfare fraud. She has a misdemeanor criminal history. It's somewhat unusual to ask for this kind of cash bail for somebody charged with one count of welfare fraud. You don't disagree with that, do you?
I don't disagree, Your Honor. What I would say is this is an unusual case. I'm not aware personally of other cases of welfare fraud where somebody was collecting welfare for about a year and a half for a child who is now completely disabled.
Thank you. Attorney Garrity?
In terms of what the mother allegedly said, obviously I'm not in possession of any reports dealing with that issue. I can tell the court that the state did make me aware of that allegation, but I don't think that indicates in any way that KAYLA won't comply with court orders. I think her history, especially the 2015 events, folks that indicate that she will, and has shown that she will follow through. And the statement, if it was made by the mother, is a statement of a concerned parent. Given the publicity this case has generated, this is, right now, simply a one-count welfare allegation. I'm sure the court knows in most circumstances, those cases, not all, but in most circumstances, do not lead to the maximum penalties outlined by the state. Most people charged with this offense are released on personal recognizance bail, given her circumstances, her ties to the area, her maturation, and her shown ability to comply with court orders. I would submit personal cognizance is what's called for.
She's unable to post any cash bail?
When I asked her mother in terms of ability of the family to post bail, the mother told me she had to contact a friend to borrow the $40 for the bail.
Thank you. All right, anything further from you, Attorney O'Neill?
No.
All right, the court's going to take this under advisement. Thank you.